Hello, this is the Kelso Report's Supreme Court Review for the October term 2010, and I'm your host, Clark Kelso. We cover the Supreme Court's October term in 4 separate installments this year: commercial and civil law, criminal law, constitutional law, and government law. In this first installment, we take a look at the major cases decided by the Court in the fields of commercial and civil law. The Court issued important decisions in securities law litigation, antitrust, intellectual property and trade regulation, civil procedure, and employment law. So let's get started with 3 cases arising under Section 10b and Rule 10b-5. Our first case deals with the question of who is accountable for making false or misleading statements under Rule 10b-5. According to the rule, it is unlawful for any person, directly or indirectly, to make any untrue statement of a material fact in connection with the purchase or sale of securities. As you all know and recall, although neither Rule 10b-5 nor Section 10b of the Securities Exchange Act of 1934 creates a private right of action for damages, the Supreme Court has recognized an implied private right of action for damages since at least 1971. Now, according to the current majority on the Court, implied private causes of action pursuant to federal statutes are disfavored as a matter of separation of powers, which means the current majority on the Court is reluctant to expand the scope of such private rights of action, and will, given a choice, interpret relevant statutory language narrowly. The Court had the opportunity to apply this narrow interpretive gloss in its opinion in Janus Capital Group versus First Derivative Traders, where the issue was whether a mutual fund investment advisor can be held liable as an entity that, quote, made, close quote, the untrue statements in a prospectus issued by the investment advisor's client, which admittedly relied upon the investment advisor in drafting the prospectus. Adopting a plain meaning definition for the word make in Rule 10b-5, the Court held in a 5-4 decision with the majority by Justice Thomas that the maker of a statement is the person or entity with ultimate authority over the statement, including its content and whether and how to communicate it. Under the Court's definition, even if an investment advisor actually drafts the language that appears in the prospectus, it is the issuer who actually has the authority and responsibility for the contents, and who, given the Court's definition, makes the statements that appear in the prospectus. And under this approach, the investment advisor is off the hook and cannot be sued for damages under Rule 10b-5. The Court defended this admittedly narrow interpretation of the word make as consistent with its reluctance to expand the scope of the Section 10b implied right of action. Justice Breyer inked a dissent for himself in Ginsburg, Sotomayor, and Kagan, arguing that the majority's ultimate authority definition for the word make was contrary to common English usage and the Court's own cases, which indicate that, depending upon the circumstances, a management company, a board of trustees, individual company officers, or others, separately or together, might make statements contained in a firm's prospectus, even if a board of directors has ultimate content-related responsibility. The dissent's observation about the prior scope given in the cases to who could be held liable in Rule 10b-5 cases has a lot of legitimacy here, which only serves to emphasize the importance of the majority's holding, which now limits the possible defendants in these cases. Well, our first case was a win for the companies, but in our second case, the plaintiffs come out on top. In Matrix Initiatives versus Siracusano, the Court rejected a proposed bright-line rule for determining materiality in a securities fraud case under Section 10b of the Securities Exchange Act of 1934, holding that a pharmaceutical company's failure to disclose reports of adverse events associated with a product could result in liability for a material omission, even though the adverse reports do not reveal a statistically significant number of adverse events. The holding is important not just for the pharmaceutical industry, but for all companies who may be tempted to look for bright-line reasons not to disclose adverse information. The company in the case, which sold the Zicam cold remedy, sought a bright-line rule based on statistical analysis. No disclosure unless statistically significant results. And the court rejected that approach as inconsistent with its test for materiality as set forth in Basic versus Levinson. In Basic, the court held that the materiality requirement is satisfied when there is, quote, a substantial likelihood that the disclosure of the omitted fact would have been viewed by the reasonable investor as having significantly altered the total mix of information made available, close quote. The court in Basic noted that any approach that designates a single fact or occurrence as always determinative of an inherently fact-specific finding such as materiality must necessarily be over-inclusive or under-inclusive. Under Basic's approach to materiality, the plaintiff in Matrix Initiatives clearly had alleged sufficient facts to survive the company's motion to dismiss. The facts indicated this was not a case involving just one or a couple of scattered, isolated reports of adverse events involving Zicam. Instead, there were reports from 3 medical professionals and researchers about 10 patients. There was an indication that the company had received additional reports, and 9 plaintiffs had already commenced product liability actions. All of these reports indicated a plausible link between Zicam and a condition known as anosmia, which involves the loss of the sense of smell. There was also some evidence of a biological causal link between intranasal application of zinc, the active ingredient in Zicam, and anosmia. Given all these circumstances, the court concluded it was likely a reasonable investor would have viewed this information as being material. The court also dealt briefly with the allegations dealing with Sienter, rather easily concluding that the allegations in the complaint gave rise to a compelling inference that the company elected not to disclose the reports of adverse events, not because it believed they were meaningless, but because it understood precisely their likely effect on the market. Finally, our third securities fraud case involves the doctrine of loss causation and the interaction of that doctrine with class action litigation. To prevail on the merits of a federal securities fraud claim, a private plaintiff must prove loss causation, that is, that the defendant's deceptive conduct caused their claimed economic loss. In Erica P. John Fund versus Halliburton, the Supreme Court this term held that a court could certify a class action without establishing loss causation, so long as the framework for establishing presumptive reliance based on a fraud on the market theory pursuant to Basic versus Levinson was met. This was an easy unanimous decision, because both parties had agreed by the time it got to the Supreme Court that the Court of Appeals had erred in requiring proof of loss causation at the class certification stage. On remand, it is clear that the defendant, Halliburton, is going to argue that there was no fraud on the market at all, thereby undermining a key element of the Basic versus Levinson framework, because the price did not react at all to the alleged misrepresentations. But that is a different theory and basis for denying class certification, and the Supreme Court refused to consider that argument on this appeal. So I hope the parties enjoyed their brief, expensive, and rather useless trip to the Supreme Court. Well, that's it for the securities law cases. To continue your review, click on the Antitrust, Intellectual Property, and Trade Regulation link in your Supreme Court Review table of contents.